Okay. John and Ian, would you kindly join us? Ian.
Yes.
Are members of the public permitted to record public meetings or take photographs?
You know, I've been reading on your blog, and somebody's busy writing letters, I forget who. We had an issue many years ago when I was a clerk, and it was deferred to the municipal attorney. And the response that came back from the attorney was that we could not deny the right for the public to record or photograph or videograph, provided it did not disrupt the meeting. We could not put them in the back, we couldn't put them on the side. This particular person sat in the first row with his tape recorder. We couldn't require a copy of the tape, but that's the way we handled it. That was a decision that he based, I think, on First Amendment rights.
Can a public body require a member of the public to get permission prior to recording or taking a photograph at a public meeting?
Is that to me?
To either one of you.
You want to go first?
I don't know. I know that what my understanding of this is that I think it was 2007, it was the Taurus versus Pine Hill case where the Supreme Court held that there is a common law right, and I don't think they said it was a constitutional right, but a common law right for citizens to videotape, audio tape public meetings. And that they held specifically that there were no privacy interests that the audience members had, and that they kind of got around all that. But they did say that the right to videotape shall be subject to reasonable time, place, and manner restrictions. Now, of course, the towns said, well, we need to really regulate the heck out of the time, place, and manner restrictions, and they do. They put all sorts of barriers. My understanding, maybe Walter is more versed in this than I am, in the aftermath of the Pine Hill decision, has there been any case law that has actually defined the parameters or the contours of what these reasonable time, place, and manner restrictions are? I think not, because, well, I haven't seen any, and I see that the towns are just adopting resolutions that provide all kinds of restrictions, and usually they are. You have to set the camera up in the rear of the room. You can't have any exposed cords. It has to be on a tripod. It has to focus on the entire council as opposed to on one individual. It has to be there for the duration. If you take it down sometime during the meeting, you can't set it back up again. And I think, and some of the ones I think that are obviously bad is they had, well, you have to have $1 million liability insurance policy, or you have to accept to hold us harmless in case, or to assume any liability for anything that happens while you're taping. And these are meant to dissuade, I believe they are intended to dissuade public access. I think what's needed is, Pine Hill is still pretty recent, and I don't know how many cases, if any, have been filed where people have challenged these restrictions. And I think that's what needs to be done, is like anything else. I mean, if what they have, if what the people who don't want you to have access to the meetings, if their only tool in their toolbox is time, place, and manner restrictions, they're going to expand that to the maximum. And we have to find out what is reasonable, and the only way to do that I know of, is through litigation or legislation. So I think the question, and correct please, if anybody has any information that differs, please let me know. I think that the courts really haven't fleshed out what is reasonable. But my own view, I took a small camera that somebody had given me, and I went to a Dunellen Borough Council meeting. I don't live there, I just like to go to their meetings. And and they really enjoy having me. And I held up my little camera, which was like the size of a cell phone, and this is what I did. I was playing with it. My son Alex is there, and I'm just holding it up, and I never really used one before, and I'm playing with it, and I'm watching, and I focus it on the clerk, and I see the clerk turn around and give me a look like, you know. But I was bothering no one. I'm sitting in my seat, and I'm just doing this. This is all I'm doing, about like this. And they immediately, with all due dispatch, at the next meeting, they had a resolution prepared to ban exactly what it was that I was doing. So they passed a policy. Now the only thing I can do is I have to attach my camera to a tripod and put it in the back of the room, as if that's less disruptive. But my sense is that if I were to actually test in court, what is unreasonable about me doing this? And how is that unduly disruptive of a meeting? And how is, this is all make-believe pretend. I mean, the camera and the tripod and the cords and the electricity, it's nonsense. It's contrivances to discourage people from exercising their right to videotape meetings. I'm convinced that there are some people that it isn't just about them not knowing or being, maybe confused. It's about a willful, purposeful effort to suppress the ability of the public to do when they see a right crop up, they want to whack it out like that whack-a-mole machine. So what I'm thinking is, I don't know, to me the question is very obvious. Somebody's got to start bringing litigation, targeted litigation, to figure out what aspects. All these things that they do in these towns are all the same. It's either a tripod in the back of the room, you have to have it set up at least 15 minutes, and you have to give 24-hour notice to the clerk. I don't know if these things are legitimate or not, because I don't know how the court would rule, and the only way that I know to get an answer to that question is to litigate it, and I don't know if, maybe Tom knows, has there been any litigation that has actually, don't put you on the spot, but has there been any litigation that has actually addressed this that you know of, or Walter?
I can't think of any.
Okay. Well, I can't. What's the number? I'll call right now. But I think that what we need to do is maybe that's where NJFOG or the ACLU can start taking action and just filing lawsuits and just finding out what the courts have to say about it and having them go up there. It's a heck of a way to have to do business, to spend all that money to do something. But I don't know any other way, because they are effectively dissuading people from attending the meeting. Because, if your son's going to get an award from the borough council or something, can't you just hold up your cell phone and take a picture of that part without having the whole tripod routine going on from 15 minutes before gavel, and you have to, it's a shame that this is the way we have to regard and deal with things like this. But I think, and I'm not one to call, let's go out and litigate, but we have to, because I don't see any other way of solving this.
Well, right. I think as folks can tell from the answers that we're getting is that there's no clear standard as to the regulation of videoing and photographing public meetings. It's sort of like, looking through a glass darkly. I think that, some of the attorneys who look at this sort of agree that advance notice requirements are probably a bad idea. Outlawing or limiting something that doesn't make any sound is also probably a bad idea. Limiting location, again, probably a bad idea. But we don't have a way of testing these thoughts outside of litigation. It's time consuming to try and litigate this stuff. Something else that I've seen that folks have sort of shot down, at least when we talk about it in private, is the notion that if somebody takes a photograph of a public meeting, then you must give a copy of whatever you took to the public agency
Immediately.
And, yes, and that's a non-starter. And it's funny because I was at West Orange. I was at West Orange's zoning board meeting, and the chair wanted to regulate, photography and videoing, and he said, "Oh, well, I think it's a good idea for the clerk to maintain a copy of whatever video or photographs were taken." And this was so beyond the pale that even other members of the board were like, "Well, I'm not really sure if we can do that." So then this guy, who's a lawyer, says, "Well." He says, well, maybe we can pass a policy requiring them to retain a copy of what they've recorded for 4 years. And it was funny. Fran.
Welcome to my world. Why wouldn't this be an opportunity to provide give a provision in the proposed legislation to clarify this issue of videotaping or?
You know, I know it's addressed, but sitting here, I just don't remember whether or not it's specific. And I can see out of the corner of my eye, John flipping through pages.
Yeah,
You know, my
it's here.
concern is that it gives, you know, some standard like, you know, shall not interfere or subject to reasonable regulation, which
here's
doesn't
what it
really
says.
tell us anything.
Here's what it says. It actually says this a little bit. It's better than it could be. It says a public body, other than the legislature, of course, that exempts themselves from everything, shall permit all proceedings of any public meeting to be recorded, photographed, audiotaped, videotaped, broadcast, or recorded for broadcast by any member of the public or news organization, subject only to such reasonable rules as the public body may adopt prior to the meeting, to minimize undue disruption to its meeting. So the three words that jump out is adopt prior, and so they can't just ad hoc say, get that camera out of here.
Everyone agrees on that. It has to be prior.
Then they say, but to minimize undue disruption of the meeting. I like that because it means that if the camera has a slight whir to it, you know what I mean? That's not undue. That's just maybe possibly disruptive. So again, it'll cause the courts to sort of have to define what this means.
Right. You know, which reminds me, you know, when I was at this zoning board meeting I went to, you know, the room was sort of loud, and it was, you know, at the board you had folks with computers and they were tapping away, and all the noise was coming from the board. So this notion that a camera or something has to be silent is silly, because the world is not silent. You know, especially when they're using electronic devices right up there making noise.
Isn't this the time, though, to get that such language as disruptive defined, to give clarity, since we now have some provision going into the proposed legislation?
I don't know.
Well, isn't this the time to really give clarity to the issue, to define the issue so that there isn't a need to do affirmative litigation, you know, do any litigation? Since the legislation has not been adopted yet, can't we get better language in there regarding photographing, videotaping?
Sure. I think the problem is that I think at least where a lot of people are, I know where sort of I'm at, is we kind of got this thing about ready to launch. And I'm a little hesitant, I mean, just to try to tinker with it more, because the perfect is the enemy of the good sometimes. And that's what I'm saying is I don't want to, I'd rather have this now, personally, than I would have something better maybe later. So I think you're right that this would be an excellent opportunity to do that, but this bill has already been sort of brokered out, you know, and everybody seems to be okay with it, sort of. So I don't know, I just don't want to derail it. Although I agree with what you're saying, I'm just worried about the legislative process and what will happen if too many more fingers go into this pie.
Is there a question?
I'm kind of wondering what would happen if, let's say at the front two tables, three of the people took their cell phones and called a friend somewhere and just had that call going on for the length of time that they cared about. So now you got three audio recordings of this whole meeting right here today.
Right.
They got their cell phone, like in my pocket here, but I might have called somebody. I bet it wouldn't be disruptive to anybody. I don't care if I see the expressions on their faces. Why couldn't that happen?
I don't know why. I think that just people don't like I do know, and I have noticed, I've seen meetings where they were not videotaped, and then I see the nature of the whole attitude and demeanor of the public officials does improve when the video cameras are on them. And it's remarkable. I mean, my son and I go to one particular public body, and we
Would that be
video.
Denellen?
No, that would not be Denellen. That I cannot, because I don't have a tripod and everything else that they require me to have. But we would go to the Board of Fire Commissioners in my township, and I noticed that there was a marked difference in the way in which they appear and the way in which they answer public questions when there's cameras on them, because they know I think it's a very positive influence on them to, and I say them, I guess the council or the public body, to be under video surveillance, sort of, in their official functions. I think it's a good thing. I think that what we need to do is probably we need to start opering the regulations, if any, that govern these, and start to compare and contrast them and find out, you know, what are the common things, and perhaps have to do the litigation on some of the things that we find most objectionable. And one other thing I wanted to mention, and it hasn't been mentioned yet today, is that another agency that is not subject to OPRA, a whole bunch of agencies that are not subject to OPRA at all, or they play by their own rules, are the New Jersey court system. The New Jersey court system has a photography policy, has a camera and media use policy that restricts, you cannot even have in a courtroom a small recorder in your pocket, like you were talking about, Gaylord, a small recorder that would just innocuously record the occurrences that happen. That is against the law. The only exception to that is if you are a member of the recognized media, which does not include people such as me, which I'm just merely a blogger, who can hold and have a tape recorder as an aid to their reporting. And I just find something really objectionable about why would something is open constitutionally. I mean, courts are very important, and when they should be subject to total scrutiny by the public. Why is it that we are not allowed to have an audio recording of what occurs, and we have to rely upon the official transcripts of those proceedings, which are expensive? And why is it, and I don't know of any other instance where distinctions are made between the citizens and the press. The press and the citizens are usually always treated about the same. I mean, you know, if the press can do it, then the citizen can do it. If, you know, I have a right to attend a meeting, a media representative has a right to attend a meeting. And there's something a little bit frightening about saying that, well, the press, if they are with a generally circulated newspaper or broadcast that is recognized and licensed, when they are able to do something and have a device to enhance access to a public event, that as a regular citizen I'm not entitled to have. And that rule is I just want to make people aware of it, that while we have obtained a right to have video recordings, that even with restrictions, of the public meetings of the executive or like the local government branch, we are still precluded from doing exactly those same things, even to the point of a silent audio recording of a court proceeding. And I don't know why that is, and I'm not sure what I just find that that's a little, it's just a little disturbing to me personally, and I just thought I wanted to share that fact with, if you want to go to the Supreme Court's New Jersey Judiciary Guidelines, or to the website, look up the public access or the camera and photography policy adopted by the Supreme Court of New Jersey, and you'll see it'll bear out what I'm saying.
Tom, did you want to be recognized? Okay. Yes, sir.
Here, but I probably broke that law. I was in Trenton for a day, videotaping one budget. It turned out one right after the other. Union County was trying to get some bond passed, and I videotaped that hearing in front of theirs for an hour. And then I walked down the street to a courtroom because they were, this was Judge Hurd saying that the cost of living adjustments on retirees' pensions can be taken away. And it was massive. I mean, there weren't a lot of people there, but this was a major, major deal. And I had my camera with me, and I was in the back, and I just, no tripod, nothing. I just stood there. I mean, I sat there and took it. And I don't know, there were no signs saying no cameras, and nobody stopped me. I didn't bother anybody. But then a couple of days, and I put this on, I have a little blog, 200-300 people, nothing major. But, so I don't know whether I was considered a member of the press, but 2 days, 3 days after I put it up on the blog, I got a letter from someone I knew who said the Attorney General's office sent a letter to Judge Hurd saying somebody, you know, no specific name, they described me pretty badly, but was filming in your courtroom. And it looked like something, a matter of intimidation. Actually, I sent something to the ACLU right after that, and they responded within 7 business days, I guess. But generally, the response from ACLU was, if anything else happens, tell us. For now, we can't do anything. And nothing else happened. But Is that a gray area? Did I break a law there?
I think
when
you
was-
probably did. I mean, that's the rule is the rule. I'm not sure if the rule is constitutional or if the rule was decided before the Supreme Court pronounced in Taurus. But the courts, it's fascinating to me that the people that we look to adjudicate our rights under the Open Public Records Act and the Open Public Meetings Act and to enforce our rights to openness and First Amendment rights of free speech and everything else, in and of itself is so secretive. And I think that people just should realize that there are, that you really should read that policy and see what it is that you are allowed to do and what not allowed to do, and wonder why it is so verboten to audio record like a municipal court hearing, which I think is sometimes I would like to audio record, because as far as I'm concerned, the audio tapes that you have, I've never actually heard one. They won't let you listen to them. Every time I've tried, you always get told, go down and buy a transcript for $350 if you want to know what was said. There's something wrong with that. These are our courts. These are courts that are supposed to be helping us. These aren't supposed to be secret to that degree, and I'm offended by it. That's true. Now, the superior courts have raised up, they have now, well, that's not always the case. Now, if they do have the video and the audio recording, and many courtrooms have them now, you can purchase those recordings, and it's very well done, and it is $10. Why it's $10 as opposed to $1, I don't know. I've never challenged that. But I have been before certain judges who still use court stenographers. There is no court, and I think they're a dying breed. But there is nothing to prevent a court, whenever it chooses to have a court stenographer record the event as opposed to an audio recording or a video recording. So in those cases, still the same problem exists. The only official record that is permitted of that recording is the one that's retained by the court at a cost that's prohibited to most members of the public.
Ian, did you want to say something on this
No,
issue?
it's fine.
Okay.
It's a little off topic, but I just wanted to bring it up. Yeah.
Now, shifting a little bit to meeting minutes. Ian, when you were the clerk, how quickly did you prepare regular session meeting minutes and closed session meeting minutes?
Well, minutes turn to hours, hours turn to days, days turn to weeks. When I got around to them, I prepared them. I got the public part out regularly. Closed session was last on the list, and the work
Why didn't you
session-
treat them the same?
Time.
Why are closed session minutes not as important as open session minutes? Because the law doesn't distinguish between closed session minutes and open
No,
session
but I,
minutes,
as
right?
the clerk, distinguished and allotted my time accordingly. I felt that the public wanted to see what everybody voted on, and closed session didn't get released that rapidly, so I had plenty of time to get those done, and the work session, get them a month late, whatever.
Was this the practice in Bergen County?
No, it was my practice. I'm being honest.
Sure.
I know you are.
I think there's a number of municipal clerks that carry on that same practice.
Now, if you came in and asked me for a certain set of minutes, and John did, I got those minutes up and out and prepared and voted on and presented to John in a timely manner. So if you wanted them, you got them. If you didn't want them, I just put them in line so that I get them out in an orderly fashion, that's all.
John, how should clerks be dealing with this issue?
Much better than he described. I think the clerks need to, well, first off, there's a benefit of having the minutes done promptly because it's fresh in the clerk's mind, and the notes, I know when I take meeting minutes of a firehouse meeting or whatever I take it of, I know that if I do them the day after the meeting, they're much more accurate than they are if I have to look at my notes a week later and figure out what's going on. But I think that the courts have said that the meeting minutes need to be made public, and this is an odd thing. There is nothing that I know of that requires a set of public meeting minutes to be approved by the municipal governing body or the public body before being released to the public. And that seems to be just a an ongoing thing that everybody seems to think the meeting minutes have to be approved.
John, is that because the draft minutes are non-binding?
Yes, the draft minutes are non. Now, according to the Government Records Council, they're also advisory, consultative, and deliberative. That's Pree versus Lower Always Creek, but that's not a good decision, and it's unfortunate. But even the clerk's own manual says that you should just mark them draft. In other words, the purpose of approving the minutes is to make sure that the members who are present at the meeting can look at what the minutes say and see if it's an accurate representation of what actually occurred at the meeting. The purpose of giving but that has nothing to do with giving the minutes as the clerk recalls them available to the public. Just mark them draft so that people know, well, they might change before final approval. And I don't see any reason they shouldn't be done within a couple weeks after a meeting, as a matter of course. As far as executive session minutes returns, the same answer. I don't see any reason why they have to be. I think that the nature of the only difference between executive session meetings and regular meetings are that the executive session meetings are going to be discussing topics causing some of the matter may need to be redacted to protect the legitimate governmental interest. But the timeliness of the production of those minutes in redacted form, I don't think really has to differ I don't see any logical reason why it should be any different than the closed or from the open session minutes.
Right, I mean, the law doesn't distinguish between different types of meetings, except in terms of open session and closed session. So sometimes folks hear work session,
Regular,
regular.
The session.
Yeah, a meeting is a meeting. There's no meeting of a public body that doesn't begin with a public session that's open to the public. Even if all they do is go into executive session, they have to start with an open public meeting, pass a resolution, and go into closed session. Okay. Now, it doesn't matter whether they delineated something else. They always have the obligation to prepare minutes is the same. The obligation to give a notice is the same for any type of meeting. So still, there's a lot of folks who still have these like fancy names. A caucus. It's a meeting. Did you want to?
Yes, no, I want to be sure I understand you right, all right? Because I might lean on you for this.
Okay.
In attending municipal township council meetings, at our council meeting, I'm not a councilman, by the way, I'm not a representative, there are no minutes distributed or available to the public until they are approved at a council meeting. Now, did I understand you right before, Mr. Paff?
Yes, I did. You correct.
You said that we could get them as a draft. They may be changed the minutes,
if they're
but
available.
they should be, right?
Well, if they're available. Now, this is an interesting. Now, let's say the clerk says you can't have the minutes. Okay, so 8 business days before the council meeting, you make an open request to the municipal clerk saying, I'd like to see the draft minutes of the previous council meeting.
Okay.
The clerk says, on the 7th business day, but prior to the meeting, they don't exist, so you can't have them because I haven't gotten around to producing them. Okay. That's perhaps an Open Public Meetings Act violation. That's different, and that's okay. But if it's an Open Public Records Act, and they say, oh yes, they exist, sir, you can't have them because they have to be approved first by the council before they can be released to the public, the clerk is wrong.
Okay.
Okay, that's exactly what I'm saying. And you can prove that to the clerk, and I can prove that to you. If you go to the New Jersey Clerks Association, the Municipal Clerks Association, they have a manual. They have a Clerks Association handbook or guidebook or manual that says, I think we have some clerks in the room, it says that you should, if a member of the public asks for the meeting minutes prior to if they're available, you give them to them marked draft. It says it right in the clerk's own instructional manual by their own association. So what I do is I Oprah that particular page from the manual from the clerk, and then I ask the clerk if he or she considers it consistent with that manual for the position that they're taking, and that usually convinces them, well, my own manual from my own organization is telling me that you're right, and I can't really maintain the position that you're wrong. So but now as far as if they don't have the minutes at all, they don't exist in written form, then you would consider taking an Open Public Meetings Act violation. And I would say that NJSA 10:4-14 says that meeting minutes shall be made promptly available to any member of the public who requests them. I'm not even sure about requesting them. I think they're just supposed to be made promptly available to the public regardless of whether a request is made for them or not. Okay, so that's another issue. But if I've sued and I've won cases where the argument has been promptly available means prior to the next meeting, because the idea is I'm not able to attend the July meeting, but I want to attend the August meeting. But I want to read the minutes of the July meeting prior to going to the August meeting to help me prepare my questions and comments and my understanding of what happened. So I need to see those prior to the meeting, so they say yes. And that presupposes they're not approved, because meetings cannot be approved except at a meeting. So, I mean, that returns the same answer. But if you go to my blog, I have collected the cases, Paff versus Keyport, there's Liebstein versus, I think it was Weehawken or something, and there's a bunch of cases that stand for the proposition that meeting minutes that have to be, there's some period of time within which they have to be produced and made available to the public. And that doesn't mean, and it's the same rule for whether it's essentially the same rule as to whether it's the public meeting minutes or the non-exempt portions of the private sessions. Yes.
Thank you. Mr. Luers, may I just follow up with Mr. Shore on the same thing? Since you're a retired municipal clerk, what were you guys doing when you were effectively employed there? With regards to the minutes?
Didn't I ask that question already? The answer was that he prepared the regular session minutes pretty quickly, but that he put the executive session minutes at the bottom of the pile, unless somebody specifically requested them, in which case he put them up to the top of the pile.
I missed that, okay.
Fair enough.
Okay.
Fran? There's two Frans.
It's okay, I'll be real quick. I think, John, you answered this. In terms of minutes, I asked questions on agenda items and non-agenda items. And Ian, you said that you paraphrase, and a lot of times the answers will be, Mrs. Day asked a question on agenda item A2. The board responded. But you don't know what question I asked, and you don't know what they said if I'm looking back at the minutes. So if I understand what you said before, Mr. Paff, I could write my question as well as who responded and what they said, and give that to the board secretary and have them include that.
No,
and
are
then
you a member of the municipal governing body?
No, I'm not.
No.
I'm just a
You
regular
can't-
person who
no, you
is like misquoted and.
What I said is that what my comments were that if, and we'll get into the issue probably a little later, Walter has a question about the comprehensibility of the minutes and the completeness of the minutes. But I'm saying that if you're a member of the governing body and your governing body goes into closed session and they keep very terse and bad minutes of the executive sessions, that you can create your own document, which is sort of like a shadow set of minutes, and submit them to the clerk, and they'll be maintained as a public record. But any correspondence that any citizen sends in is a public record. I mean, if you were to write a letter to your borough council and say, I wanted to, address something that happened, item 3B of the agenda, and I were to choose to OPRA that record, they have to produce it in response to my OPRA request. They have to retain it in response to the Division of Archives and Records Management schedules, because it's correspondence. So, yeah, I guess you could. But as far as the question of paraphrasing minutes, the only case law I know about that is an unpublished case by Judge Passero in Passaic County, where he said that the minutes of the meeting dealing with public portion of the meeting and the comments made by the public have to provide any information about the topic so as to ratify or to confirm that the municipality has put on notice of something. It goes to notice, is what his exact words were. So if you were to say, for instance, Mr. Mayor, I want to inform you that there's a pothole in the middle of West Main Street, or there's a dangerous condition on West Main Street. And if they recorded your comments in the minutes as being, Miss Day remarked about a public works issue, or something vague like that, the problem with that would be that if a plaintiff were to trip and fall or something in that pothole that you would describe, and the town were to try to say, well, we didn't have any notice or any knowledge that that was the case, that the minutes should be clear enough to be able to identify. Now, this is just what one judge in Passaic County said, but I do have that case, so if that ever comes up, I can provide a copy of that case. It was O'Shea versus West Milford Board of Education, I think, and it's there. But that's the only case law that I know that talks specifically about how much detail about citizen comments have to be included within the minutes of a public meeting.
Ms. Brooks?
Actually, I have a comment to make in regards to your question. There's something that I do regularly at my township meetings is when I ask a question and I want that question to be specific in the record, I ask the clerk who is doing the recording to make sure that my question is within the record of the minutes, and very specifically request that my question be provided and the answer be specific within the record. And then what happens is when it doesn't show up, because I keep detailed notes and I also record my meetings, I go back to that meeting, I reference that meeting and I say, the minutes do not reflect the question that I asked, and I make them actually correct the record.
You want, oh, that's right.
The question that I ask for those specifics, but the question, now I don't remember my question that I actually wanted to ask. I do. If a municipal agency posts its adopted minutes from workshop and regular meetings on its website, is there any obligation, legal obligation that the agency has to post its adopted executive session minutes?
No.
No.
There is nothing that requires them to post them anywhere. So if they do, it's out of administrative grace that they post them for your benefit. And if they choose to post the minutes from January and February, but not March or whatever, they can be as arbitrary as they choose to be, unless they develop some sort of a policy that you could, force them to a written policy that we're going to do such and such. But no, there's no. It'd be nice. Well, actually, under the legislation, they're going to have to put their minutes on.
All minutes, both.
I'm not sure. I have to read it again. I think so. Yeah.
My recollection is that it's all minutes. Ian, do you want to address any of that?
I mentioned earlier, and again addressing your statement, clerks are not trained in shorthand, speed writing, or anything of that nature. So you're telling the clerk you want the exact words recorded. In my case, and I would have to, and I don't want to speak for all clerks, but I could almost say to you, 90% of the clerks will never get your exact wording down, because if we leave out a word and it changes the entire context of what you said, we're at fault. So we're not required to do verbatim. We could synopsis it as long as we get what you're saying down, but not verbatim.
I think this is where it's really valuable to have the video and the audio of the meeting, and that's where, so we don't have to rely upon the written record. We can use the minutes, and I use the minutes as essentially as a table of contents. That it says that Ms. Brooks spoke about, X, Y, Z, and I would say, I think I'll skip to that portion of the meeting so I can hear what Ms. Brooks actually said about X, Y, Z, so that I can, and it sort of sets forth, the minutes set forth a sequencing. So if I see that they're still talking about ordinance 1142, and I see that's on the agenda, I can sort of gauge how far down the tape I gotta go or the recording to get to the part that I'm interested in hearing. So, the comprehensiveness of the minutes it becomes less important as there's actual video and audio recordings. But that's the problem with the executive session minutes, and I think that has to be the problem. There is no audio recording in most cases of the executive session minutes, and the minutes are so brief that it's sometimes they read more like an agenda than they do actually a set of minutes, and that's a problem.
At one point, the member of the council wanted to record closed session minutes. Closed session meetings. I brought down recording equipment. I set out the microphones. Mayor called the meeting to order. We went into closed, and there wasn't a sound in the room. Mayor would bring up a topic. Not a sound in the room. Told me to turn off the machine. I turned off the machine, unplugged it, and they had their conversation. You have to understand closed meetings. They are talking about negotiations. They are talking about lawsuits. They are talking about topics that are crucial to the municipality. Our board was a mayor and 6 councilmen. We had 7 different opinions. And the conversation got heated. And in order to come up with a final decision, this is what takes place in that room. If it's recorded, they're not going to be able to say what they have to do, what you elected them to do. Sorry, John. A closed session is something, you will see the outcome when whatever they have decided on goes into the public to be voted upon. How they got from point A to point B to bring out the resolution of that particular subject is fine. But it got there, and you are seeing the result. At that point, if you agree with it, they're giving the cops a 25% pay raise, and they're giving the other employees 2%, you, the public, can then talk about it, and you could state what you want. But they need this to talk, and that's, I mean, that was the perfect example.
I think I understand the difference. I'm going to say this about that. I understand, I have no objection to the legitimacy and the necessity of having closed sessions of public bodies. There clearly are things that they need to discuss behind closed doors that they could not, because they'd give away a competitive advantage or negotiation advantage or they give away their entire negotiation strategy if they were to discuss it in public, because the adverse party to the litigation of the contract could be in the public meeting listening to everything they're saying. But that is not to say that I think that the meetings cannot be recorded, because those recordings are like minutes. They can be redacted to remove the parts of the recording where the sensitive issues are discussed. So to me, the fact that executive sessions are oftentimes necessary to discuss personnel issues and contract and negotiations and litigation negotiations does not automatically force the conclusion that those meetings should not be audio recorded.
Speaking of conclusions, in my effort at some sort of segue, please join me in thanking our panelists. And now, I'm sure some of us will hang around, but I have to plug New Jersey Foundation for Open Government. So please like us on Facebook. Our website is www.njfog.org. Join our mailing list. Join our organization, which would be your opportunity to donate money if you wanted to. And please, especially join the email list, because I know sometimes it produces, maybe like 1 or 2 too many emails, which I then have to delete. But it's a good source for information, and I read those lists, and John reads those lists, and Ian reads those lists, so you get a lot of information that way. Also, if you want to make an inquiry to FOG, but you don't want to put it out to our mailing list, just send it to info@njfog.org. Only the board members get those. And I read them just as quickly as I read the ones on the mailing list. So please, reach out to us, ask us questions, and, support us.
Our board meetings are open to the public. I mean, you can come to any meeting we have.
Do you have a closed session, though?
We might. Not usually, though.
Not under my term. Okay. Thank you very much, everyone, for coming.